I have worked as a labor attorney in the transportation industry for over 35 years. In my experience, the concept of safety first among transportation managers is frequently an empty slogan. All too often, their primary focus is on meeting the schedule, period. The public welfare depends on you, the conscientious employee who will not back down when the safety of passengers or co-workers is at risk. Fortunately, the United States Congress has enacted a federal law, the National Transportation Systems Security Act, or NTSSA, which prohibits a public transportation agency from taking retaliatory action against an employee based on his legitimate safety complaints. The NTSSA also prohibits retaliation against any employee who furnishes information to any federal, state, or local agency, including law enforcement, concerning injuries or property damage occurring in connection with public transportation. This will be a kitchen table conversation that runs you through the basic elements of the NTSSA Whistleblower Statute. First, the concept of protected activity. What conduct on your part is protected? Second, the issue of supervisory knowledge. How important it is to be able to confirm that the individuals who took action against you had prior knowledge of your protected activity. Third, the concept of adverse action. What acts by your employer will constitute prohibited retaliation under the Act? Fourth, the limitations period. How long do you have after the adverse action to file your complaint with OSHA? And we'll give an overview to the remedies, such as compensatory damages, make-whole relief, attorney's fees, and punitive damages. The NTSSA prohibits a public transportation agency from retaliating against an employee for reporting what he believes to be a violation of any federal law, rule, or regulation relating to public transportation safety or security, or raising an issue related to the misuse of public funds. Protected activity also includes reporting hazards that present a threat to safety, or even refusing to work when confronted with hazardous or compromised security conditions. Finally, protected activity also includes providing information to any federal, state, or local agency, including law enforcement, concerning injuries or property damage occurring in connection with public transportation. The following are specific examples of employee conduct deemed to be protected activity by federal administrative law judges. Reporting a failure to use the required mats intended to protect employees from the electric third rail of a subway system. Reporting the lack of proper protective equipment to clean vomit from a train car. Or failing to provide a spotter when backing a bus into a yard between two other buses. Other examples might include reporting an unsafe rail condition or FRA violation, such as a defective track switch. Reporting a workplace injury caused by an unsafe work condition, such as an uneven walkway or defective piece of equipment. Reporting that foul time is being withheld for on-track work in circumstances where federal safety standards require that foul time be provided. Protected activity will generally include complaints regarding an employer's non-compliance with its own operations manuals, where these manuals have been subject to the review and approval of a federal agency. You do not have to cite a specific regulation or order by its number. It will be sufficient that you bring the relevant facts to your employer's attention and reference your compliance concern. The filing of your NTSSA complaint also constitutes protected activity. As long as that complaint was filed in good faith, you cannot be lawfully subject to retaliation for asserting your rights. The NTSSA operates as a discrimination statute, but it is not based on your race or national origin. Rather, it is based on actions you have taken. Consequently, in order to discriminate against you, the employer must have knowledge of your protected activity. When you engage in protected activity, try to do it in a way so that it can be proven that your supervisors and managers had knowledge of your actions. If you present your complaint orally, make sure there are witnesses. However, it is best to communicate in writing, such as letter, email, or text. Copy your complaint or other protected activity to anyone who can take retaliatory action against you. Then knowledge of your activity can be proven. The concept of an adverse action is very broad and includes actions that may not be subject to your union's grievance and arbitration process. Notably, the NTSSA fully applies to a probationary employee who may have no protection under the CBA. Termination, demotion, failure to promote, these would all obviously constitute an adverse action. However, judges interpreting the NTSSA and similar whistleblower statutes also have treated a broad range of discriminatory actions as triggering the protections of the Act, including written warnings, removal from overtime lists, and even excessive surveillance. The case law provides that any non-trivial action taken in retaliation against a whistleblower could constitute an adverse action. Why is that? Because there is a strong public interest in maintaining the freedom of speech of individuals who report safety issues, injuries, and property damage occurring at public transportation agencies. The lesson here is, do not wait to be terminated. If the employer has commenced a process of retaliatory progressive discipline, the time to act is now, before the employer has the opportunity to build a retaliatory case against you. Let's assume you have engaged in protected activity and were subsequently subject to an adverse action. How do you establish a nexus or causal link? Administrative law judges have recognized that it is rare for an employer to admit that its actions are designed to retaliate against individuals reporting safety issues, injuries, or property damage. Therefore, judges will draw inferences from a laundry list of suspicious circumstances. For example, the temporal proximity between the adverse action and the protected activity. Did you report a track issue and the very next day or the very next week you were removed from the overtime list? Pretextual rationales. After you engage in protected activity, were you punished for being 5 minutes late when everyone else is given a 5-minute grace period? Shifting rationales. Did they give you one explanation for giving you a written warning and then change the rationale a week later? Withholding a rationale. Was someone disciplined or terminated and not given any reason at all why the adverse action was taken? Unlike other discrimination laws, you do not have to demonstrate that your protected activity was a substantial motivating factor with respect to the adverse action you have suffered. Due to the safety imperative underlying the NTSSA, the statute creates an extremely light burden on employees with respect to the issue of the employer's motivation. You need only show that your protected activity was a contributing factor. A contributing factor is any factor which, alone or in connection with other factors, tends to affect in any way the outcome of the decision. If you have engaged in protected activity and subsequently suffer an adverse action, you have 180 days from the date of the adverse action to file a complaint with the OSHA Division of the United States Department of Labor. Remember, the 180-day limitation period is measured not from the date of the protected activity, but from the date of the adverse action. Let supervisors know you filed the complaint. That filing with OSHA is a separate and distinct protected activity event. Any additional action taken against you after you have filed your OSHA complaint will be subject to heightened scrutiny by the agency. The remedies provided under the NTSSA include make whole relief, such as back pay, lost benefits, restoration of seniority. Also, affirmative remedies, such as the purging of your personnel file or mandatory postings of safety notices in the workplace. Reasonable attorney's fees if you prevail in your case, to put starch in your shorts and subsidize the enforcement of safety standards. Compensatory damages, that's compensation for your emotional distress. The NTSSA even provides for punitive damages up to $250,000. Remember, the first step is filing a complaint with the OSHA Division of the United States Department of Labor. It is not required that you have an attorney represent you at the time of the filing, and most complaints are filed without the assistance of an attorney. However, you should address the basic elements for an action under the statute: protected activity, supervisory knowledge of your protected activity, the adverse action that was taken against you, and some reference to evidence supporting a causal link between your protected activity and the adverse action. The NTSSA is a great equalizer that gives you the right to resist pressure to violate safety standards or cover up injuries and property damage. You are in a safety-sensitive industry. There are times when it is critical to the safety of others that you speak. The United States Congress enacted the NTSSA to afford you protection when you do.